So, my lord, when there are extraneous considerations, your lordships would step in and exercise the power of judicial review, and extraneous would mean completely irrelevant and not germane to the issue. Issue namely whether the governor would be justified in forming an opinion or entertaining a doubt about the government having lost the majority support. If the documents are not irrelevant or not germane, then, my lord, perhaps your lordships may not take a second guess on the basis as to what your lordships would have perhaps perceived the situation to be capable of. I had 47 members before me saying that we don't want to support this government. We want to withdraw support from this government. That is itself an enough ground in my respectful submission. Your lordships were pleased to record, my lord, several past cases where the governor either decided to direct floor test, parties came here and your lordships did not intervene, or governor was not directing floor test, parties came here and when required sitting at midnight, your lordships directed that immediate floor test, and the only purpose was that there is no time for either pressure, threat, coercion, violence, allurement, etc., etc. Whatever is the will should be reflected at the first available opportunity. Therefore, your lordships, my lord, sat at night in case of Karnataka. There are several such instances. So therefore, I was saying that you should not only command the majority support at the time of formation of the government, you must continue to command that. That's the democracy. So it is only in extraordinary circumstances that there would be a departure from floor test rule. Otherwise, floor test is the rule. Well, that's what, my lord, the test your lordships were pleased to lay down. Because when we say, my lord, that defection is the highest political sin, Lord, running a government after losing the confidence of the electorate, namely the House, is a larger constitutional sin to which governor should not be a party. Continuous existence of that trust gives you the legitimacy in democracy. Lord, now this is 11 is important. Lord, the argument was that floor test could not have been ordered because they, this side and other independents, etc., who withdrew support from the government, they should have gone for no confidence motion. And this is a new point, my lord, which I would be urging for your lordship's consideration, not argued, my lord, so far. First of all, my lord, whether it is a floor test, which is a motion of confidence, or a no confidence motion, my lord, which is negatively worded, the result is the same, and therefore that can never be a ground to invoke your lordship's equity jurisdiction in a 226. Floor test also, the numbers will be counted and people would decide whether I have the majority. In no confidence, numbers will be counted and members would decide whether I have the majority. But there is something more than that. Lord, please come to PDF page 40 of Convenience Compilation 3C. Lord, the provision in the Maharashtra Legislative Assembly rules regarding no confidence motion. Lord, your lordships are confronted with a situation where the governor is receiving representations that we have withdrawn support, we want to withdraw support, etc., etc. I am not repeating. There is a threat of violence. There is in fact violence. Attacks are taking place at the houses. And now, my lord, the submission is that you should have allowed the no confidence route rather than directing a floor test. Your lordships have said, my lord, please bear in mind that such floor test cannot brook any delay. And why this reliance on no confidence motion? Maybe they wanted more time, which the governor prevented them from doing. Rule 95. Your lordships have that? Rule 95? Yes. Well, two things I'll say at the outset and I'll read this. First, any member can move a no confidence motion only when House is in session, not otherwise. House was not in session. Number two, it depends upon the discretion of the speaker whether to allow the motion to be placed or tabled or not. It's not a right. So again, I'll be dependent upon the discretion to be used by the speaker if I'm the elected representative. This is what, well, therefore, governor says that no, you hold a session. So first, he can sit for 1 week to decide whether to permit this or not. But if he admits, then the members will seek leave to make the motion for on such day not later than 2 days after it is admitted. Your Lordships are deciding this constitutional principle that whether the governor was right in directing summoning of the House for floor test, and they are saying that no confidence motion was the route, meaning thereby this threat, allurement, violence, etc., continues, and the governor's satisfaction that prima facie the government has lost confidence would continue without any legitimacy. Borrowing your Lordships, very, very pertinent expression. After the member has asked for leave of the assembly to make the motion, the speaker shall read the motion to the assembly and request those members who are in favor. That's the procedure, my lord, how the motion would be passed or failed. So, my lord, this is no remedy in fact situation like this. Because the taste, my lord, right from the state of Rajasthan till Shivraj Singh Chauhan is, it cannot brook any delay. Last 3 points. Another option was 356, which is frowned upon, and nobody, that has to be the last resort. And how that happened, please come to as a last submission. Written the documents which I have placed. The governor received 2 letters that now Eknath Shinde has the majority. And another very risky argument which Mr. Sibal made, that why did the governor call Eknath Shinde to form the governor? And why not the president of the party was consulted? My lord, the governor knows only the elected leader of the house. He is not concerned with political parties. There are political parties where leader of the house is in fact the leader and president is not controlling him from somewhere else. Governor has to contact the elected leader of the legislative party. When he is shown, my lord, I'll show, my lord, those documents. There are 2 letters, my lord, I'll show that document. Because, my lord, every party has a different structure. Kindly see, my lord, the mischief in this argument. I'm saying argument, not mischief in making of the submission. Lord, mischief. I'm sorry, my lord. I thought, my lord, it might be
there. Relieved with your clarification.
No. It was not correctly worded, my lord. The potential mischief if this argument is, my lord, accepted. That's what I wanted to convey. Lord, every party has a different party infrastructure. For example, in some parties, the highest authority is the general secretary. There is a Politburo in Communist Party. General secretary is the highest authority. In some, my lord, there is a body, 5 people, my lord, committee or something. In some, there is a president. There may be a dispute who is the president. Governor would not enter into that. Governor would say that who is the leader of the legislative party. Governor would deal with only leader of the legislative party, and Mr. Uddhav Thackerey, who did not face the confidence and therefore he resigned, is not even a member of the Legislative Assembly. Provided links to videos where Mr. So-and-so has openly stated that dead bodies would come, and I would, my lord, earnestly urge, my lord, not to condone this. My lord, this is a threat in public platform. My lord, let us not, my lord, lessen the gravity of it. It's a very serious thing. I leave it at that.
Law and order situation.
I leave it. No, it can be law and order situation also. But if that law and order situation is being created to bring pressure on the legislative process, then it's not just a law and order situation. It is one of the major considerations for the governor that yes, he seems to have lost majority and now open threats are being administered that you come in our fold or you will be sent to post-mortem. It's a threat to death. I would, my lord, earnestly request your lordships, my lord, that it cannot be taken serious, my lord, lightly by the constitution.
That I leave it a ground for unseating a government. I mean, ultimately, that somebody who makes that state is subject to section 156(3), is subject to an FIR. You can do what you want about that.
Allow me to, my lord, put it differently. My lord, that's where the perception differs. If I say that because somebody is threatening, you face the floor test, then your lordships are right. But when I have the letters that we want to withdraw support and we are being threatened, then it's not that reason. That's the ground, not the reason.
The trust vote. What is the purpose of the trust vote? In a house of 288, do you have 144? That's the purpose. And if there is nothing to indicate that 144 is disturbed, who will lead those 144 is alien to the governor. It may not have been Uddhav Thackeray. They could have elected somebody else. The INC, NCP, and the Sena would have said, "Oh, we're electing somebody else."
Would your lordships come to page 21? There is a directive.
That is a matter of internal party discipline. You see, that can never be a matter for the governor. Governor's trust vote is where the majority in the House is shaken. And where was there anything to indicate?
They say, we don't wish to support this government. Meaning,
No, Mr. Mehta, if you will look at para 11, that's the conclusion. We demand security. That's all. They don't say we are parting company. Where do they say that? They say, please give us adequate security as also our family because it's been
the
withdrawn.
governor is not, a court where this prayer was not couched in this manner. He has to, based upon the material before him, arrive.
Mr. Mehta, what is being pointed out, what is being pointed out is this communication cannot be said to be withdrawing the support to Mr. Uddhav Thackeray. This is that what happened earlier, what happened that.
With what it says. It may say they give us protection, but they say we no longer want to be a part of this corrupt government. Meaning thereby 47 people are minus now
And they
from the magical mark.
What is being pointed out, then thereafter they don't say further that henceforth, correct, we are not supporting this.
If it is a petition, there is no prayer.
For the subjective satisfaction.
Please note one difference. It's not legislative party members showing lack of confidence in their party. It's not their internal party affairs anymore. These members are saying that we are withdrawing support from the government. That's the distinction. And I would hasten to add, that this not being, a petition or a suit may not have a prayer clause, etc. But governor, as I will show from one para of Bomai, from whatever material, if he comes to the prima facie satisfaction, and that test is accepted by my lords, in the Shivraj Singh Chauhan judgment, that there is loss of confidence by this government, then he can ask, not only can ask, he should ask the floor test. 47 members of the Legislative Assembly, not just Shiv Sena MLAs, but independents and 2 members of Prahar Jan Shakti Party saying we are withdrawing support from the government. No, it's past and continuous also. That we have already declared that we don't want to support. But now we are being pressurized to support. That's what.